My name is Peter Rudy. I am a management employment law attorney, and I just gave a presentation on employee misclassification. This is a topic which has become incredibly important recently, in large part because of the economy. As the number of employees have been terminated, can't find other work, they look at avenues for some sort of remuneration. The number of wage and hour cases in my practice has quadrupled since '08. It was a very small part of my practice. Now it's over half of my practice. What does misclassification mean? Well, there's two areas in misclassification. One is misclassifying an employee as an independent contractor. It's important to realize that certain words should never be used when talking about this area of misclassification. We don't use the term contract labor anymore. It's a very dangerous term. Employees are workers for a company are either independent contractors or they are employees. Lots of tests. Now, the IRS has a test. There is the Fair Labor Standards Act under the US DOL has a test, and even Colorado Workers' Comp Administration has a test. But they basically focus on two things to determine whether or not an independent contractor really is an independent contractor. One part of the test looks at control. Who is controlling the work of this independent contractor? If the contracting party exerts a lot of control, particularly control in how the work is done, not what is done, then chances are that worker is an employee, not an independent contractor. The other factor which comes up, and there's other tests, are known as the economic realities test. And what that looks at is what are the economic realities of the situation. One way of summing it up is if the worker really just sort of works for this one client, if this worker, his or her finances sort of rise and fall on this one client, then that person will generally be an employee. A lot of other factors to look at. Interestingly enough, no factor in any of the tests is controlling. What's great about the test, though, I think that employers, attorneys representing companies should look at the test as food for thought. Look at these tests as actual checklists, and look at the test as thoughts of how you can make an employee an independent contractor. And what can we do? As an example, one of the tests talks about supplying tools, things of that nature. Who supplies the tools? Well, an employer could then say, or a contracting party can then say, gee, to make this person independent contractor, we're going to require her to buy their own tools. Maybe we'll pay extra, but they have to supply their own tools. So independent contractor status, the most important thing to take away from that is it makes no difference what your contract says, it makes no difference what title you use, that what makes a difference is what is actually done. The other area is exempt, non-exempt. Exempt, non-exempt means exempt from the overtime provisions of the Fair Labor Standards Act. There are a bunch of exemptions out there, and again, those exemptions will talk about what makes somebody exempt and what doesn't exempt from the overtime provisions. And just like with independent contractor, it makes no difference what their job description or title says, it's what they actually do. So before anybody is classified as exempt from Fair Labor Standards Act, you really need to go through checklists to make sure they really qualify for the exemption you want. The exemption, which is the most dangerous, and it's the one used most often because it uses a lot of wishy-washy language, is the administrative exemption. If you feel you want to use the administrative exemption, you really need to be very careful, because chances are, if you're audited and it's found to be incorrect, the US DOL will pursue it.